Picture this scene. It's deep winter in South Yorkshire, 2010. A young man named Paul is standing at Robin Hood Airport staring at the departure board. Heavy snow has grounded everything. He's cold, he's tired, and he's just desperate to see his girlfriend. And in a moment of pure, relatable frustration, the kind we've all felt when our travel plans just completely disintegrate, he pulls out his phone. He taps out what is just a stupid, obviously sarcastic joke on Twitter. He writes, "Crap, Robin Hood Airport is closed. You've got a week and a bit to get your shit together, otherwise I'm blowing the airport sky high." He hits send, probably chuckles to himself, and then he goes home. He assumes his followers, his friends, will see it for exactly what it is, just him venting about bad weather. But the reaction wasn't a laugh. It wasn't a retweet. It was a visit from the anti-terror police. Paul was arrested, charged, and then dragged through the court system for 2 whole years. A high court judge, thankfully, eventually ruled the tweet was just jocular, but by then, Paul admitted the whole process had destroyed a substantial part of his life. Now, what's truly chilling isn't just that this happened to one guy, it's that he is now the norm, not the exception. In the UK today, police arrest an average of 33 people every single day, not for robbery, not for violence, but for things they post online. It creates this bizarre, suffocating atmosphere where a bad joke can get you a criminal record, yet actual threats, well, they often go ignored, depending on who makes them. It forces us to ask, at what point does keeping people safe actually become a convenient excuse for total state control? And maybe more importantly, how long until that same knock on the door happens here?
That anecdote is, it's the perfect chilling starting point, really. Because what happened to Paul Chambers, it was only possible because of a fundamental systemic difference in how democratic societies approach freedom of expression.
Right. It's not just one bad law, it's the whole foundation.
Exactly. So in our deep dive today, we're going to look beyond just that one case. Our mission is to analyze the foundational disparity between the U.S. legal tradition, where, the bar for limiting speech is extraordinarily high, and the European framework.
Which is the framework that has, as you say, enabled these vague, content-based criminal laws to just flourish, leading directly to what Paul faced.
Yes, and then we'll examine the UK's really ambitious attempt to modernize and fix these over-criminalized communication laws. They're trying to shift toward a much more focused harm and intent model.
Okay, so there's a potential solution on the table.
There is. But finally, and this is maybe the most crucial takeaway for you listening, we will analyze the inherent risk that even perfectly crafted, precise laws can pose when they are applied unequally across different parts of society. Because that's what really damages public trust and ultimately social cohesion.
Okay, so let's unpack this. We're looking at a huge philosophical divergence in the West. On one side, you have the U.S. focused on maximizing speech almost at all costs.
Almost, yeah.
And on the other, the European system, which appears, just much more comfortable with the state regulating certain types of content. So let's start with that European baseline. What does the ECHR, the European Court of Human Rights, what does it actually say about protecting expression?
So the ECHR sets the standard for pretty much all of Europe, and its baseline, on paper at least, is very strong. It holds that freedom of expression is one of the essential foundations of a democratic society.
That sounds good. Essential.
It's absolutely vital for things like, individual self-fulfillment, intellectual exploration, and critically, the ECHR has repeatedly stressed that this freedom extends beyond information or ideas that are benign or popular.
The easy stuff.
The easy stuff. They explicitly state that it protects those ideas that offend, shock, or disturb.
And that's the phrase, isn't it? Offend, shock, or disturb. That's what you always hear defense lawyers citing. It sounds like an ironclad defense against being arrested for, wow, a rude joke.
It should be.
So if that protection exists, where does the loophole come in? Where's the exception that allowed Paul Chambers' prosecution to even get off the ground?
Well, the protection is, unfortunately, almost immediately undercut by a major caveat in the foundational documents themselves. Specifically, it's Article 10, Paragraph 2 of the European Convention on Human Rights. It says freedom of expression is subject to exceptions. Now, the courts do say these restrictions must be construed strictly, meaning the state has to really convincingly establish why the restriction is necessary. But here's the key mechanism that shifts all the power.
Which is?
The European framework grants national governments a significant margin of appreciation.
The margin of appreciation, right? We hear that term a lot in European legal circles. For you listening, how does this concept practically diminish that robust ECHR standard? What does it actually look like on the ground?
It's the central difference between the two approaches, U.S. and European. The margin of appreciation means that national governments, not the pan-European court, are given a huge amount of leeway of latitude in judging what circumstances warrant restrictions on speech.
So they get to decide what's necessary for them.
Exactly. It allows individual states to tailor restrictions based on their own particular cultural, social, or, political context.
So if Germany feels that because of its history, it needs to have incredibly strict laws about certain political symbols, the ECHR is likely to just defer to Germany's judgment of what is necessary in their society, even if it restricts speech way more than, say, Malta would.
That's a perfect example. The ECHR will say, we recognize this broad principle of free expression, but we grant you, the sovereign government, the appreciation of what is necessary in your unique circumstances. And if a government just cites national security or the prevention of disorder,
which is easy to do,
it's especially in a post-9/11 Europe that's highly sensitive to terrorism. That margin of appreciation often means the national courts and the police are just given the benefit of the doubt, even if the resulting law is incredibly vague or broadly applied. And that subjectivity is exactly why defining and prosecuting hate speech becomes such a complete legal minefield.
It seems like that lack of a clear, uniform definition is the inherent vulnerability. If the government can restrict speech if they think it's necessary, and if the thing they're restricting, hate speech, is itself just nebulous, how can anyone possibly comply?
The problem of legal certainty is profound. It's huge. If you look at European legal guidance itself, it often describes hate speech as, and I'm quoting here, literally lacking a definition. It's described as being incredibly difficult to identify and as speech that can sometimes even appear rational or normal to the person speaking it.
Wow, that admission is chilling.
It is. Because if the law itself admits it doesn't know how to define the crime, how can a citizen possibly regulate their own conduct to stay within the bounds of that law? You can't.
It forces instant self-censorship. It's what lawyers call a chilling effect, right? You don't know where the line is, so you just stay miles away from any kind of real debate, just in case.
You stay in the safe zone.
Let's bring in a case study here to show how this lack of clarity plays out. We have the example of Vesdeland v. Sweden from 2012.
Yes, Vesdeland is the textbook example of where that ECHR protection for ideas that offend, shock, or disturb just completely failed, utterly. This case involved 4 high school students in Sweden. They decided to distribute about 100 leaflets that were critical of homosexual behavior.
Okay, so critical leaflets. And where did they distribute them?
They placed them in or on pupils' lockers at an upper secondary school.
So they weren't like shouting at people or inciting violence. They were just distributing a critique on a social issue. How did the legal system handle that?
The Swedish Supreme Court convicted them for agitation against a national or ethnic group, which is a crime that carries up to 2 years in prison.
2 years for leaflets.
And when this got to the ECHR, the court acknowledged a really critical point. The leaflets did not directly recommend individuals to commit hateful acts. The students weren't telling people to go attack gay students. They weren't doing that at all. And yet the court upheld the conviction.
On what basis? I mean, if they didn't incite violence, how did the ECHR justify stripping away that protection for speech that merely offends?
The ECHR ruled based on the subjective quality of the content. They deemed the comments to be serious and prejudicial allegations, and crucially, insulting. The court went on to elaborate that attacks on persons can be committed through insulting or holding them up to ridicule or slandering specific groups.
So it's about the tone, not the threat.
It is. And the key phrase they used was that this kind of speech, if used in an irresponsible manner, may be deemed unworthy of protection.
Irresponsible manner. I mean, that is somehow even vaguer than grossly offensive. The entire basis of the conviction rests on a moral judgment of the quality and responsibility of the speech, not on any imminent threat of action.
Precisely. And this is the profound consequence for you, the citizen. It's impossible to distinguish between protected speech that is merely offensive or shocking, which the ECHR claims to protect, and unprotected speech that is deemed serious and prejudicial or delivered in an irresponsible manner.
There is no line.
There is no clear line. And that legal uncertainty creates a massive chilling effect where political debate, especially on sensitive topics, is just constrained by the fear of the state stepping in to make a subjective judgment about the quality of your argument.
What's truly shocking, though, is the historical context behind creating these content-based restrictions. It seems to completely flip our modern understanding of which political ideologies favor broad free speech and which favor state regulation.
Oh, it is the ultimate historical irony.
Yeah.
You have to rewind to the drafting of the Universal Declaration of Human Rights, the UDHR, right after World War II, with the specter of fascist propaganda just looming over everything.
Right.
At that time, the liberal democratic nations were the staunch proponents of maximum free speech protection. They argued for the broadest possible latitude.
So who was on the other side? Who was pushing hard to carve out those exceptions, to implement explicit hate speech restrictions prohibiting advocacy of national, racial, or religious hatred?
It was the communist nations. They aggressively proposed language to constrain Article 19, which is the part that protects expression, both in the UDHR and in the later International Covenant on Civil and Political Rights.
And the democracies pushed back.
Fiercely. The US, the UK, and others, they resisted this. They argued that if you want to combat bad ideas, you fight them with better ideas, with counter-arguments. They explicitly warned against using penal law, law backed by prison time, fines, to suppress what they called subjective offenses. They called it a barbarous practice.
A barbarous practice. That is profound. The very nations that originally warned that regulating subjective offenses was a barbarous practice that handed control to the state. They are now the most enthusiastic implementers and users of these very laws.
It's a complete reversal.
And it sets up the perfect contrast with the U.S. system, which has, for the most part, maintained that original democratic impulse to fight ideas with ideas.
It does. The U.S. counterpoint, rooted in the First Amendment, stands in stark relief because its focus is almost entirely on action, not on the content of the speech. The American constitutional tradition requires tolerance for speech that is insulting and even outrageous.
And the core idea there is what?
The core tenet is that the government cannot prohibit an idea simply because the majority of society finds it offensive or disagreeable.
So if the U.S. system insists on tolerating even outrageous speech, what is the established legally recognized boundary? When does protected offense finally turn into unprotected action?
The line is set incredibly high by the Brandenburg test. This standard ensures that speech advocating the use of force or illegal action is only restricted if it meets three simultaneous, really rigorous criteria.
Okay, what are they?
First, the advocacy must be directed to inciting or producing imminent lawless action. Second, that action must be imminent. It has to be about to happen right now. And third, the advocacy must be likely to actually incite or produce that action.
So if it fails on any one of those three direction, imminence, or likelihood, the speech is still protected.
Still protected. It's a three-legged stool. Kick one leg out and the whole thing falls. The speech remains protected.
So Paul Chambers' sarcastic joke, which was clearly not directed toward imminent lawless action, the airport was already closed, he was at home, it would never ever meet that U.S. standard.
Not in a million years. It's designed to be an almost impenetrable shield for hyperbole, for venting, for satire.
And it's neutral, right?
Completely. The entire test is context neutral and content neutral. It's not interested in the morality or the offensiveness of the idea, only in the immediate, tangible threat of violence or illegal conduct. Furthermore, U.S. law absolutely prohibits what's called viewpoint discrimination in all public forums.
Let's focus on that concept of viewpoint discrimination because that seems to relate directly to how Europe tries to prosecute hate speech. How does U.S. law prevent the government from singling out specific forms of offensive speech, like, say, those targeting a particular race or religion?
Well, if a government tries to craft a law that punishes insults, only if they're based on protected characteristics, like race, gender, sexual orientation, but doesn't punish insulting speech in general, that law is unconstitutional under the First Amendment.
And why is that?
Because the law is handicapping the expression of particular viewpoints. You can't single out a particularly hateful or obnoxious viewpoint for punishment because the government is effectively stepping in and saying, we agree with the content of this message enough to protect it, but we abhor the content of that message enough to criminalize it.
The state can't be the referee of ideas.
Precisely. The U.S. system demands that if you're going to criminalize insult, you have to criminalize all forms of insult equally. You can't pick and choose based on whose feelings you think are more important.
That's a fundamentally different legal philosophy. It's night and day. The U.S. trusts the marketplace of ideas no matter how harsh it gets, and restricts the state to only preventing imminent action. Europe, on the other hand, grants the state power, through that margin of appreciation, to restrict speech if it's just deemed subjectively irresponsible or prejudicial.
Yes.
And this brings us right back to the UK, which had inherited a set of laws that really embodied the absolute worst aspects of this subjective regulation, the laws that allowed the Paul Chambers case to happen in the first place.
Exactly. The system that caught Paul Chambers was based on decades-old, incredibly vague legislation. We're talking about Section 127(1) of the Communications Act 2003 and the Malicious Communications Act 1988. These laws criminalized communications that were grossly offensive, indecent, or menacing.
Grossly offensive might just be the most subjective legal standard imaginable. I mean, if the ECHR struggles with irresponsible, grossly offensive, must be completely unworkable in a diverse modern society.
It is entirely unworkable. These are what are called category-based standards that lack any universal definition. And that leads to random, inconsistent, and often just unjustifiable interferences with freedom of expression. The UK Law Commission, when they reviewed these laws, concluded they did two things very badly.
What were they?
They simultaneously undercriminalized truly harmful online behavior like coordinated harassment campaigns, pile-ons, and scandalously overcriminalized harmless acts.
Can you elaborate on that over-criminalization part? Besides sarcastic jokes, what else was technically a crime under these old, vague laws?
Well, the example that's often cited is private consenting adult communication. If two consenting adults exchanged explicitly sexual text messages, those messages were technically indecent.
So they could be prosecuted.
They could technically be prosecuted under these statutes. The law was just far too broad. It allowed police and prosecutors to interfere in private lives based on really subjective moral standards rather than any genuine provable harm.
And the history of Section 127 is key here, isn't it? It really illustrates just how obsolete these laws were.
Oh, it's a spectacular legal hangover.
Yeah.
Section 127 is a direct descendant of the Post Office Amendment Act 1935. This law was literally designed to deal with one very specific, very 1930s problem.
Which was?
Young men using public telephone boxes to make free calls to female telephone operators and then making obscene remarks to them.
You're kidding me?
No. It was a law designed for a manual switchboard system and was entirely unfit for the age of social media, where 1 billion posts are made every week. It was technology-specific, it was category-based, and it was focused on moral content, not on actual harm.
So the UK Law Commission saw this complete mess, the subjective language, the inconsistency, the massive overcriminalization, and decided they had to pivot entirely. What is the core conceptual shift they're recommending to build modern functional laws?
The shift is a full rejection of that old content-based system. They recommend replacing all the old offenses with a single technology-neutral, harm-based offense. So the focus moves from what category does this content fall into to what harm did the sender intend to cause. And this focus on intention, it's everything.
Okay, let's break down the mechanics of this proposed new offense. What are the 3 non-negotiable elements that the prosecution would have to prove?
Right. First, the prosecution must prove the communication was likely to cause harm to a likely audience. Second, they must prove the defendant intended to cause harm to that audience. And third, the defendant sent or posted the communication without a reasonable excuse.
Okay, let's drill into that first element, likely to cause harm. This is where the UK is trying to draw a bright line between protected offensive speech and unprotected criminal behavior. So what's the legal definition of harm they settled on, and what's the crucial threshold?
The Law Commission was very, very deliberate here. They define harm as psychological harm, amounting to at least serious distress.
Serious distress.
Yes. And this is a fundamental safeguard. They explicitly chose this standard to ensure it required a significantly higher threshold than, say, general harassment offenses.
And general harassment only requires alarm or distress, right?
That's right. If you harass someone, the law only requires proof of alarm or distress. But for this new, more serious communications offense, which carries a potentially higher penalty and is used to regulate public discourse, they demanded serious distress. This is the first line of defense for robust debate. A communication has to pose a real or substantial risk of causing debilitating psychological suffering, not just general offense or annoyance.
That seems like a massive improvement. It filters out the low-level subjective offense cases like Paul Chambers right away. But the absolute game changer, the thing that really separates this from the old vague laws, seems to be that intentional barrier. They specifically chose to require intention to cause harm, and they rejected a lower standard. Why was that distinction so important to them?
It was a point of significant debate during their consultation. Initially, they considered a lower threshold of recklessness.
And what would that mean in practice?
It would mean the offense could be proven if the defendant was merely aware of a risk that their communication could cause serious distress.
Which sounds like an easier standard for the police to prove. Why did they ultimately reject it? Doesn't a lower standard like that catch more bad actors?
They rejected it precisely because of the potential for disproportionate interference with freedom of expression. If the standard was just awareness of risk, think about it. A journalist publishing a deeply critical investigative piece that exposes corruption.
They know it's going to cause distress.
They know it will. Or a doctor delivering extremely difficult news to a patient's family. They could theoretically be prosecuted. Both of them know their communication will cause serious distress.
So by requiring intention, meaning the defendant must have acted in order to bring about that serious distress, you protect all that legitimate, though difficult, communication. The doctor's purpose is to inform, not to inflict suffering.
Exactly. Intention requires purpose. If you cannot prove that the core purpose of the sender was to inflict serious distress, the offense cannot be made out. This constraint is absolutely vital for insulating contentious political speech, critical journalism, and satire from criminal prosecution.
And even if you could somehow prove intent and harm, the system has a final safety valve, that reasonable excuse element.
That's the final and maybe the most explicit defense for public debate. The court must consider whether the communication was or was intended as a contribution to a matter of public interest.
So it's a public interest test.
It is. It ensures that even if a statement is harsh, causes serious distress, and the sender knew it would, if their overall goal was to contribute to public discussion or policy, the court has a mechanism to dismiss the charge.
Let's use a highly contentious public scenario to see how these three elements, harm, intention, and reasonable excuse, work together to protect robust, even unpleasant debate. Let's take the example of a pylon on Twitter involving a controversial public figure.
Right. A great, very modern example. Let's say we have an MP, we'll call her Ruby. She makes a comment on a sensitive social issue, and she is immediately subjected to a massive barrage of responses, many of which are truly vile.
Okay.
Scenario A involves a person sending Ruby a purely derogatory, individualized tweet. Something like, "You deserve to lose your job, you pathetic idiot. Hope your family gets sick."
Right. Pure abuse.
The intent there is clearly to cause distress. There is zero public interest justification, and the harm is likely to be serious. That would be criminalized under the new system.
And rightly so. But what about scenario B?
Scenario B involves a political commentator, let's call him Mohammed. He tweets, "MP Ruby is wrong. Her policy proposal is economically illiterate and dangerously naive. See my article link." Now, Mohammed knows Ruby is being abused, and his tweet, while it's policy-focused, is certainly contributing to her overall distress. But what was his intention?
His intention was to criticize policy and, drive traffic to his analysis, not to inflict psychological harm.
Correct. So even if a Ruby suffers serious distress, and even if Mohammed was aware she was stressed, his primary intention was policy critique, and his communication was undeniably a contribution to a matter of public interest. The reasonable excuse safeguard ensures he walks free.
So the system shifts the entire focus away from the subjective offense taken by the recipient and back to the objective culpability and purpose of the sender. That is the fundamental difference from the old, grossly offensive standard.
That's the whole ballgame right there.
This shift is clearly a huge leap forward in legal protection for free speech in the UK. But we also have to look at the kinds of specific, high-harm behaviors that the Law Commission felt needed their own tailored offenses because the general harm-based standard just wasn't enough. The first category is threatening communications.
Yes, even with the new general harm-based offense, there was a consensus that genuine threats needed separate, specific legal recognition. This isn't just about covering psychological harm. It's a matter of what's called fair labeling in criminal justice.
Fair labeling.
It means the name of the crime should accurately reflect the wrongdoing. A specific threat of violence is inherently more severe than a general message intended to cause distress, and the law needs to reflect that gravity.
So how does the new framework define a threat? And how does it make sure that a sarcastic, jocular threat like Paul Chambers doesn't get swept up again?
The new offense targets communications conveying a threat of serious harm. And serious harm is defined broadly to include threats of serious injury, like grievous bodily harm or GBH threats of rape, and even threats of serious financial harm.
Let's just clarify that jargon for a second. When we say GBH, grievous bodily harm, in UK law, we're talking about really serious harm, aren't we? It's the highest level of non-fatal violence.
Precisely. The really serious harm. And the culpability here is based on either intending the victim to fear the threat or being reckless as to that fear.
So recklessness is back on the table here.
It is for threats, yes. Unlike the general harm-based offense, where they rejected recklessness, they permit it for threats. And the reason is that the act of communicating a threat of serious violence is inherently more culpable than sending a merely offensive message.
That makes sense. If you genuinely communicate a threat of rape and you are simply reckless as to whether the victim believes you, that is still a highly criminal act. But if we go back to Paul Chambers, his high court defense successfully argued his tweet was jocular. Under this new law, if he didn't intend the airport staff to genuinely fear imminent serious harm, he's protected.
He is protected because the new framework focuses on genuine intent to instill fear of serious harm. It raises the bar significantly from that old menacing standard, ensuring that exaggeration, venting, or satire, the jocular comments, fall outside the criminal threshold.
Okay, shifting gears now to the modern digital landscape. Let's discuss cyberflashing, which has become frighteningly common, especially in crowded urban public spaces.
Cyberflashing is a widespread and insidious form of sexual violence. It involves sending unsolicited images of genitalia, often via peer-to-peer sharing methods like airdrop on public transport, in cafes, on university campuses.
And the impact is serious.
It causes profound feelings of fright, vulnerability, and often a fear of escalation. For victims, it is not a nuisance. It is often experienced as a highly personal sexual assault.
So why did the Law Commission insist that this needed its own separate offense, specifically within the Sexual Offenses Act 2003? Why not just cover it with the new general harm-based communications offense?
This is a really critical legal detail that demonstrates why classification matters so much. While the general harm-based offense would certainly cover the psychological harm caused, the overwhelming consensus was that cyberflashing is an act that is sexual in both substance and form.
And by including it in the Sexual Offenses Act, that does what?
It unlocks crucial post-conviction measures.
What kind of measure?
They're called ancillary orders. And the most powerful one is a sexual harm prevention order, or an SHPO. For you listening, an SHPO allows the police and the court to place significant restrictions on an offender's behavior after they're released. It can restrict their access to specific technologies, their locations, even their contact with certain groups, all designed to prevent reoffending and manage dangerous sexual offenders.
And the general communications offense can't do that.
It cannot grant these specialized tools, which are essential for victim safety.
That's a practical difference that moves beyond just punishment and into long-term public protection. And the proposed offense covers images of genitalia regardless of whether they belong to the sender. Is that right?
Correct. The core harm lies in the non-consensual receipt of the image, the shock, and the sexual nature of the intrusion, regardless of whose body is pictured. So the proposed solution is to make it an offense to send an image or video recording of genitals, whether the senders or not, to another person, either intending to cause alarm, distress, or humiliation, or just being reckless as to whether it would.
Finally, there is a very specific and very physical threat that modern digital tools facilitate. And it targets a particularly vulnerable group, people with photosensitive epilepsy.
This is perhaps the darkest example of malicious communication, because the intent is to cause direct physical injury, not just psychological harm. The most public incident that was cited was the attack on the Epilepsy Society's Twitter account.
What happened there?
Their account was barraged with over 200 posts containing rapidly flashing GIFs and violent imagery over just a 48-hour period, specifically intending to trigger seizures in its 26,000 followers.
That is a direct physical attack designed to inflict serious injury. But you noted that prosecuting this under existing laws, even the laws against physical harm, was surprisingly difficult. Why was that?
The difficulty arose when police tried to prosecute this under the old Offenses Against the Person Act, specifically for maliciously causing grievous bodily harm, or GBH. There were two complex hurdles. First, proving GBH. The prosecution would have to prove that a seizure by itself met the threshold of really serious harm. That's a legal tightrope walk. Second, and this is the major practical difficulty, causation. If the victim already suffered from epilepsy, proving beyond a reasonable doubt that the flashing image was the singular cause of that seizure, rather than their pre-existing medical condition, proved incredibly difficult for prosecutors.
So because the victim was already vulnerable, the law actually made it harder to prosecute the attacker for intentionally targeting that vulnerability. That's a huge gap in the protective framework.
Exactly. The existing law, perversely, protected the malicious attacker because of the victim's pre-existing medical condition. So to close this specific gap, the recommendation is a new, precise offense: intentionally sending flashing images to a person with epilepsy with the explicit intent to cause them to have a seizure.
Which bypasses the ambiguity.
It bypasses the ambiguity of the GBH standard and the difficulties of proving causation by focusing purely on the highly specific, malicious intent behind the action.
Okay, so we've established that the UK is attempting a substantial and, frankly, sophisticated overhaul of its subjective communications laws. It's replacing them with precise, harm and intent-based statutes with strong safeguards for public debate. This is all excellent on paper. But now we turn to the critical point raised in the opening story. The ultimate failure of law happens not in the drafting room, but in the streets, through unequal enforcement.
This is where legal theory clashes violently with enforcement reality. The most meticulously written statute, even this new UK harm and intent model, is utterly undermined if the law is perceived as being applied selectively or if it targets some segments of society while excusing others.
And the result is?
The immediate consequence is a rapid and profound erosion of public trust in the rule of law and the institutions that enforce it. We have a potent case study of this damage in the situation in Northern Ireland.
What examples from Northern Ireland highlight this perception of two-tier policing?
Well, the contrast is stark, and it's immediate. On one hand, you had senior political leaders receiving no prosecutions for very public and egregious breaches of COVID regulations during lockdowns. These were high-profile events that undermined the entire public health effort.
Right.
On the other hand, in the very same week this non-prosecution decision was made, we saw at least 12 individuals in Londonderry, specifically loyalists, being summoned to court.
And what were these loyalists being prosecuted for?
They were being prosecuted for an illegal assembly that had taken place 4 years earlier. The gathering itself was related to loyalists trying to peacefully tackle ongoing antisocial behavior, violence, drug abuse in their specific community.
Wait, so let me get this straight.
Yeah.
In the same week, powerful people get a pass for breaking major recent public health laws, while a group of community members are prosecuted for a 4-year-old assembly where they were trying to deal with crime.
That's it. The core irony is that 4 years later, the people who had assembled to address antisocial behavior were summoned, while those in power who broke serious recent laws were excused.
That comparison is breathtaking. It just screams political, selective enforcement.
It creates an undeniable perception of two-tier policing. It sends a message that the powerful are above the law, while marginalized communities are subject to delayed, punitive legal action, often for minor or outdated offenses. And this disparity, it just damages respect for the police, for the justice system, and for the democratic process itself.
And when that trust is eroded, a vacuum is created.
It is. And other forces, specifically criminal organizations and paramilitaries, are sadly all too quick to exploit it.
And the tragic societal fallout of this cynicism is felt most acutely by the young people who are then drawn into the resulting chaos.
It is a devastating, self-perpetuating cycle. You have disadvantaged young people, already isolated and often enraged by dangerous political rhetoric from leaders who act with impunity. They're easily preyed upon by criminal gangs involved in drug dealing, intimidation, and organized crime.
And they're the ones on the front lines.
They're the ones who end up carrying out the violent acts that make the headlines attacking public servants like bus drivers, police officers, or press photographers.
And when the inevitable response from the criminal justice system comes, it is these young people who bear the full brunt of the law.
Absolutely. The sources highlight that it is these young, loyalist individuals who face the full wrath of the criminal justice system. They acquire criminal records that severely limit their life ambitions, their educational opportunities, their employment prospects.
While the people who stoked the fire walk away.
The politicians and powerful figures who orchestrated or stoked the unrest using inflammatory language are often shielded from the legal consequences, while the vulnerable youth they radicalize or angered have their lives ruined.
So we arrive back at that chilling atmosphere that Paul Chambers faced, the fear of a knock on the door for low-level, subjective offenses. But now it's scaled up into a national crisis of social cohesion. The fear isn't just that the law is vague, but that the law is a weapon used disproportionately.
That is the essential conclusion. The fundamental problem is not just the existence of broad, vague laws, but how selectively and disparately those laws are applied across society. When democratic institutions fail to protect citizens equally or prosecute all citizens consistently, it fuels deep cynicism. Open debate becomes vulnerable because people fear that their expression, if it's controversial or critical of the state, will be treated as a criminal offense, echoing Paul's 2-year ordeal.
So the legal reform is only half the battle.
The UK Law Commission may have done excellent work in creating a more precise legal instrument, but its effectiveness ultimately depends entirely on ensuring that instrument is wielded impartially and consistently across all communities so that the law remains a tool for justice and not a sword for political control.
So what we've seen today is the sweeping contrast between two major legal systems. The U.S. system, which prioritizes freedom of expression, allowing wide latitude for speech we all find offensive, rooted in that belief that only imminent, lawless action justifies censorship.
Right, a very high bar.
And then the European system, lacking that equivalent foundational shield, allowed these vague, content-based laws like the grossly offensive standard that ruined Paul Chambers' life to just flourish. While the UK is now engaged in a positive and vital effort to modernize, shifting toward a model rooted in proving genuine harm and explicit intention.
That reform effort can't succeed in a vacuum. The system's integrity, its very legitimacy, relies not just on the letter of the law, but on its impartial, consistent application across all segments of society. And that, in practice, remains a profound challenge.